So, the Supreme Court has decided that the government was acting illegally in proroguing Parliament. Having spent a considerable amount of my time picking my way through their 24-page judgment, this is why I think it's utterly wrong. On the face of it, I think we should first admit that many will believe that the judgment of the most supreme court in the land should be taken very seriously. The whole system starts to fail if we routinely question the validity of its judgments. It's therefore incumbent upon the Supreme Court that its judgments are absolutely solid, and therefore its reputation, and by association the reputation of our entire legal system, is not unhinged by it making poor judgments. In other words, we will inevitably judge the judges, and we should not be inhibited in doing so, particularly when they seek to give legal justification for overturning political decisions. It's not our responsibility, but it is the court's responsibility to maintain its reputation for justice. The fact that the decision of the Supreme Court was unanimous is odd. This was an appeal of a High Court decision, yet all 11 Supreme Court judges disagreed with the High Court. Surely you'd expect some differences of opinion at the very least. And this is a very unusual circumstance. The court is overruling the monarch, the government, and in practice, it's overruling the people. In its judgment, the Supreme Court lays out all the events that occurred before the prorogation of Parliament. Point 30 of its judgment says this: first, the power to order the prorogation of Parliament is a prerogative power. That is to say, a power recognised by the common law and exercised by the Crown, in this instance by the Sovereign in person, acting on advice in accordance with modern constitutional practice. It is not suggested in these appeals that Her Majesty was other than obliged by constitutional convention to accept that advice. Essentially what it's asserting is that the monarch is required to act on the advice given to her by the government. Again, we're back to this advisory argument. The Remainers argue that the EU referendum was advisory, and therefore it can be set aside. Yet the courts say that advice is an instruction, something that's obliged by constitutional convention. Well, okay, but you can't have it both ways. If advice is to be taken as an instruction, then the advice of the ultimate sovereign power, the people, must be enacted, and attempts to prevent its being enacted must be quashed, not empowered by legal judgments, surely. In its judgment, the Supreme Court says that proroguing is not unlawful in itself, it's the normal convention. But the court deems that this prorogation is unlawful because of the length of time involved. And this is the nub of it. Because who does it turn to for evidence for this pivotal question? Well, disturbingly, it accepts the, and I quote, unchallenged evidence of Sir John Major. So this is the Sir John Major who himself prorogued Parliament for 3 weeks in 1997 and was accused of doing so because it avoided the publication of a report on the Cash for Questions scandal before the general election of that year. Point 59 says, the unchallenged evidence of Sir John Major is clear. The work on the Queen's speech varies according to the size of the programme, but a typical time is 4 to 6 days. So let's get this straight. John Major is giving evidence that the proroguing is too long, and in so doing he admits his own guilt of unlawfully proroguing Parliament? Or is he saying things have now changed? The judgment utterly fails to address this point at all. Why on earth is the court accepting the evidence of someone who himself has prorogued Parliament for a very considerably longer period than he now conveniently suggests is the typical time needed? Why on earth would he be considered a reliable witness? The court refers to other evidence submitted by the appellant Gina Miller that fails to provide any conclusive evidence of the reason for the prorogation, and then delivers the basis of its judgment. 61. It is impossible for us to conclude on the evidence which has been put before us that there was any reason, let alone a good reason, to advise Her Majesty to prorogue Parliament for 5 weeks from the 9th or 12th September until the 14th of October. We cannot speculate, in the absence of further evidence, upon what such reasons might have been. It follows that the decision was unlawful. So the court is saying it has no evidence that the reason for the length of prorogation was unreasonable, except the totally contradictory evidence of Sir John Major. So it decides in the absence of further evidence that it must have been unlawful. What? This is patently, obviously wrong. There's a very fundamental legal principle here. Unless the appellant can prove the government did it for the wrong reasons, the judgment cannot be made against them. It's a basic presumption of innocence, surely. Now, you and I might speculate that the government did prorogue to slow down the Remainers who want to destroy the democratic basis of our nation, but surely, if the court wants to pursue this line, it should have just required the government to provide evidence for why it needed to prorogue for the period that it did. Until I read the judgment, I really thought I was probably just going to have to conclude that for all the protestations there was some sound, logical, legal basis for this. But now I have. I can't begin to justify why the court's behaved like this. I can only conclude that it's utterly wrong, and it's acting with the establishment to overturn the decision of the people. And for the record, the court did not make a damning judgment against Boris Johnson, as many are now suggesting. It did not say he lied. That is just more nonsense. It just assumed guilt without evidence to support that assumption. I can't quite believe we're living through this. Every day the behaviour of those who are against the democratic decision of the people just gets worse and worse. To see our future videos, subscribe to our YouTube channel and click the bell icon. That way you'll get a notification by email as soon as a new video is available. In the meantime, please do help us out and like and share or retweet this post so your friends and followers can see it too. Thanks for watching. Please do share this so that at least some of those who dismiss the protests against this judgment realise that there is something deeply wrong here. See you next time.